And you know that at the end of every year, the clerks give the Chief Justice a photo, and that you always put on that photo kind of the line of the year, right? And so this morning, I went into the Chief's office to look at those photos because I thought I would get some good lines to give you and ask you to vote. But I decided it wasn't really going to work, because here's what I found. When you ain't got nothing, you got nothing to lose. I mean, I don't think that that's even the Chief's, really, which I just wrote an opinion about that, you know, that. Or here's another one. Unfortunately, the canvas looks like one that Jackson Pollock got to first. That must have been before the Chief became a modern art fan. Tough as a $3 steak, as inexplicable as it is unexplained. Gives euphemism a bad name. What chumps? Well, maybe John Roberts doesn't really sound like Henry Friendly. I thought he sounded a little bit like that other Justice Kagan or something. But then I realized that he was here first, so Kagan must sound like him. I don't mean to reduce the Chief's opinion writing to a few funny lines. It's not representative of all the Chief's writing is and all it can do. That writing is, in my humble opinion, the best writing in law. Now take the two things that I said and combine them. Felix Frankfurter once said of learned hand this, that there was a happy conjunction of thought and its expression, and that conjunction resulted in enduring statements of legal principle. And that's what I always feel when I read the Chief Justice. He is a consummate legal craftsman. He writes intelligibly and powerfully about the most difficult issues in the law. He produces work of great insight and analytic strength and penetration and eloquence. Now, why is this important? Because, let's be frank here, there's a lot that the Chief and I don't agree on, except apparently about copyright. Where we are two kindred souls, if lonely ones. But you know, on many other matters, there is sometimes that I really could tear my hair out about the things he thinks, and I'm sure he would say the exact same thing of me. And those things that we disagree about, they have consequence. They matter. They matter in our society, they matter in people's lives, and that shouldn't ever be forgotten. But still, the kind of judicial craftsmanship that John Roberts exemplifies and shares with Henry Friendly, his clarity, the intelligibility of his writing and his thought, his analytic precision, his ability to see and organize and make lucid whole areas of law, his ability to explain, not only to lawyers but to a wider public, what his decisions are based on. Those qualities, they're more than craft. They're the foundation stones of the rule of law. One might say they're aspects of law's internal morality. They're an important part of what separates law from dictate. They enable law to provide a guide for future conduct. They make law something that can actually be followed by other judges and citizens. They offer transparency and accountability. They show how rules of decision are arrived at, and they show how to criticize them. And finally, those qualities of the master legal craftsman, they encourage, even if they don't guarantee, law that in its substance is careful and restrained and principled. And so I want to close along those lines with something that John Roberts said about Henry Friendly, and he said this at his confirmation hearing. He said, Judge Friendly had such a total commitment to excellence in his craft at every stage of the process, just a total devotion to the rule of law and the confidence that if you worked hard enough, you'd come up with the right answers. And it was his devotion to the rule of law that he took most pleasure in. And one day, Chief, one day I'm confident that one of your clerks at his or her graduate confirmation hearing will say the same about you, and it will be just as true. And it is why I am very proud to present you today with the Henry Friendly Medal.
Well, I have nothing to add. Justice Kagan, a deal's a deal, and I'm not going to tell you what the deal is, but you shouldn't look for any Justice Kagan ERISA opinions for a couple of years. Other than a few comments here and there, this is the first time since pre-COVID that I've given remarks of this extent, certainly before an audience like this. And when I sat down to sketch some of these remarks out, it occurred to me that I'd forgotten how to go about it. But then I remembered, first thing you have to do is begin with a joke. So with all these lawyers present, I thought I would tell a lawyer joke. But then I remembered you shouldn't tell lawyer jokes because the lawyers don't think they're funny and the non-lawyers don't think they're jokes. President Levy, Director Wood, members of the ALI, you cannot know how meaningful this award is for me. Judge Friendly's robe that he wore when he was on the Second Circuit hangs in my closet in the robing room at the Supreme Court. On my desk, I have a bas-relief of Judge Friendly's profile executed by Elliot Goldfinger, who also did the sculpture of Judge Friendly that is in the Second Circuit main courtroom. It looks across to the sculpture of Learned Hand. Yes, he was the greatest judge of his era, but I think that sells him short. He was also, for example, one of the founding partners of a firm that was known as Cleary, Gottlieb, Friendly, and Cox. He was at the same time the general counsel and vice president of Pan American Airlines when Pan Am was the dominant air carrier and also a significant instrument in American foreign policy. He was a significant academic in the law through his articles and addresses, many of which are still worth reading today. He was very active in a group called the American Law Institute, and he did a number of other things like leading the campaign to raise money to build the first international law building at Harvard Law School. He had an extraordinary impact on the law. But his impact on me was a more personal one. In 1979, when I came out of law school, I was wondering if I had made the right choice in shifting from history, which was my first love, to the law, because I thought the law school was a rather cynical place. I don't mean that to be singling out my law school. I think it was probably endemic. And I thought that the law was a rather cynical profession. Certainly a good place if you wanted a job to make money, or a good place if you wanted to advance a particular objective and you could use the law to that end. but not an enterprise, a job worth being characterized as a noble calling. And I did think that I had made a mistake, although I was glad that I was doing well enough. Interestingly, Henry Friendly had made the same transition when he graduated from Harvard 100 years ago in 1923. When he came and announced to his parents, after he was done with the Shaw Traveling Fellowship, he was going to come back and pursue a PhD in history. His mother, according to David Dorson's biography, was horrified. And she prevailed through various connections to have Felix Frankfurter talk to her son and dissuade him from academia and encourage him to go into the law, which Frankfurter succeeded in doing. Now, I had transitioned from history to law because I also had an interview with a particular individual. I was coming back to school from home in a cab from Logan Airport, and the cab driver, asked me, said, well, what do you do? And I said, well, I'm a history major at Harvard. And he said, well, what do you know? I was a history major at Harvard. And that's when I decided I would give law a try. But coming out of law school in 1979, I really did wonder if I had made the right call. And then a year with Henry Friendly changed everything. I saw on a day-to-day basis, an eye-to-eye basis, that a good and full life could be led in the law. Yes, Judge Friendly was brilliant. Yes, he had a photographic memory, but it was his unrelenting hard work in the service of a passion for the right result, for the right reasons, that made him great and, at least to me, inspirational. His commitment was not limited to great cases. They extended to the most mundane. What Friendly said of Learned Hand was true of himself to an even greater degree. Quote, he would make the tiniest glowworm illumine a whole field. I'm sure many of you have heard the story that Justice Jackson tells of the three stonemasons. The older Justice Jackson, not our Justice Jackson, but it's about a passerby who comes upon these three stonemasons. They're working, they're doing the exact same thing. And he asks the first one, he says, well, what are you doing? And he says, I'm making a living. Okay. He asks the second one, what are you doing? He said, I'm arranging these blocks in a particular pattern that I've been instructed to follow. They came to the third one and said, well, what are you doing? And the person lifted his eyes to the heavens and said, I am building a cathedral. Judge Friendly, in his work, was always building a cathedral, no matter how significant or how insignificant. What Learned Hand said of his teachers, Friendly said was true of Learned Hand, and this can surely be said of Friendly as well. In the universe of truth, they lived by the sword. That sounded to me like an exhilarating fight, and I wanted to be a part of it, and I still do. I am very honored to accept this medal, not as an award, but as a continuing challenge. Now to the American Law Institute, congratulations on 100 years. 100 years ago, this building still housed the original tenant, the Pension Bureau, and I was fascinated to learn that they were administering pensions to 40 widows whose husbands had died in the War of 1812, in 1923. I didn't believe it, so I looked it up, and it's the case. In 1923, Yankee Stadium was built, the first one opened. The Hollywood sign came out. Disney was incorporated, so our organization goes back a long way. Charles Evans Hughes once described the ALI as a, quote, roundup of intelligent discontent, end quote. That is still a good label, and I think we should be proud of it. Now, over the past 100 years, ALI has educated the profession, courts, and legislatures about what the law is and what it should be. And to the extent I can speak on behalf of courts in America, thank you very much for that significant contribution to the rule of law. and I wish you an equally successful second century. I am not sure what the friendly medal presentation will look like in 2123, but I suspect that artificial intelligence will be involved somehow. Now, Judge Friendly's stature in law is based on his opinions. I've looked at a bunch of them, and I've been helped in that enterprise by David Dorson's biography, and in particular, Judge Posner's preface, which is worth reading. Judge Friendly's opinions demonstrate, to me at least, three significant aspects of his craft. First, he had an open mind. Second, he had tremendous power of reason. And third, he had a pragmatic perspective. An open mind. Judge Friendly's colleague on the Second Circuit, Judge Feinberg, said that Friendly, quote, carried the full sweep of law in his mind. It was not limited by any predisposition. He wasn't pro-prosecution or pro-defendant. He wasn't liberal or conservative. You could ask his clerks. The liberals will say he was liberal, the conservatives that he was conservative. That wasn't a lexicon that he operated in. His mind was not limited by any being a disciple of any school of thought. It was not limited by any theory of legal philosophy. He was open to all arguments and would engage with all of them. Many of you, I'm sure, has experienced what is true of so many Friendly opinions. When you get one, it's cause for joy because no matter how insignificant the issue is, the entire body of law will be spelled out for you. He delighted in fitting a particular case in the context of the law as a whole. Second point, compelling reason. In his opinions, all of the steps are laid out. There's no hiding the ball. There is no sweeping the pieces off the chessboard. This is what Judge Posner said about it. Quote, his analytic power, energy, speed, and work ethic made him the most powerful legal reasoner in American legal history. He applied reason, not ideology, analysis, not slogans, or mere case citations. Pragmatism. Again, Judge Posner. He tempered academic brilliance with massive common sense. The opinions for him were never a game. They did involve real people. The system had to work. They were not sterile. They told a real story. Now, as a general matter, those principles are good for judges, but they're also not bad for other officers as well. Yet much of the public discourse seems today very different. Instead of openness, most views being discussed seem to come prepackaged. Instead of reasoning, you get slogans and shouting. Instead of pragmatism, you get wacky theories that have no realm of being real in possibility. Now, as a result, truth, someone said, would be like a vintage sports car, too valuable to take out and use. Which leads me to one area where I part ways with the man that I'm so proud to call a mentor. Judge Friendly was, I think, a pessimist at heart. He was, I know, very proud of his work. You could see it in his face when he was satisfied with the product. But if he were alive today, the contrast between his efforts and things going on outside his chamber would be deeply disappointing to him and would feed, certainly, any depression. There's much in the legal arena that he would find abhorrent. Judge heckled and shouted down at a law school, protesters outside the homes of justices, to the extent that martial protection is needed 24/7. In 18 years, I'm asked, well, what was the hardest thing, what was the hardest decision I had to make in 18 years? Was it this First Amendment case? Was it that death penalty case? Was it some major separation of powers case? None of those. The hardest decision I had to make was whether to erect fences and barricades around the Supreme Court. I had no choice but to go ahead and do it, but while it was going on, while the fences were going up, I kept hearing Charles Evans Hughes's remarks at the opening of the Supreme Court building. He said, "The Republic endures, and this is the symbol of its faith." But inside the court, there's cause for optimism. I am happy that I can continue to say that there has never been a voice raised in anger in our conference room. Our court consists of 9 appointees by 4 presidents. We deal with some of the most controversial issues before the country, yet we maintain collegial relations with each other. When I wander down the halls and see a colleague, I am always happy to have the chance to chat. Now, to be fair, there are many days where I don't feel like walking down the halls, so you may have to discount that a little bit. And on a final issue of concern inside the court, I want to assure people that I am committed to making certain that we as a court adhere to the highest standards of conduct. We are continuing to look at things we can do to give practical effect to that commitment. And I am confident there are ways to do that that are consistent with our status as an independent branch of government under the Constitution's separation of powers. Thank you very much for the Henry Friendly Medal. It means the world to me. Thank you.
Well, thank you to all our justices, and thank you everyone for being here tonight. Hope you enjoyed that. I think it was very special. The buses will be available to return to the hotel, and we will reconvene tomorrow at 8:30 in the ballroom for another talk by another early career scholar, Francis Shen, on how neuroscience will change the law. So we've had AI, now we'll have neuroscience. What's next? Thank you all. Have a great evening. Bye-bye.